The foundation of a transparent and accountable government rests upon the ability of its citizenry to observe and scrutinize the actions of public officials. In an era increasingly defined by digital media, the act of recording law enforcement officers engaged in their public duties has emerged as a potent instrument of this oversight. It is within this context that recent pronouncements by the Department of Homeland Security, DHS, have generated significant legal and constitutional concern. High-ranking DHS officials have publicly asserted that the act of filming and posting videos of Immigration and Customs Enforcement (ICE) agents constitutes prosecutable offenses, equating this activity with violence and doxing. This report offers a comprehensive legal analysis of these claims, directly confronting the stark contradiction between the DHS's public posture and the well-established constitutional rights of the American public. The central thesis of this analysis is that the DHS's position is legally untenable, resting on a deliberate mischaracterization of protected constitutional activity and a gross misapplication of federal criminal law. The department's statements appear to be less a good faith interpretation of existing statutes and more a calculated effort to intimidate the public and create a chilling effect on a vital form of government accountability. To substantiate this conclusion, this report will proceed in 5 distinct parts. First, it will deconstruct the specific allegations made by DHS officials, examining the rhetorical and legal implications of labeling recording as violence. Second, it will critically analyze the potential federal criminal statutes that the government might invoke, specifically 18 U.S.C. Section 111 and 18 U.S.C. Section 115, and demonstrate why the non-obstructive act of recording fails to meet the essential elements of these laws. Third, it will dismantle the doxing allegation by defining the term and showing that the DHS's usage is factually and legally baseless, particularly in light of proposed but unenacted legislation. Fourth, it will present the dispositive and affirmative case for the First Amendment right to record public officials, a right that has been uniformly recognized by every federal appellate court to have considered the issue. Finally, this analysis will be fortified by an examination of state-level statutes that explicitly codify and protect this fundamental right, showcasing a broad legal and legislative consensus that stands in direct opposition to the DHS's claims. Ultimately, the act of recording public officials is not a threat to be prosecuted, but a right to be protected.